What is the situation regarding personal liabilities of directors? This is a discussion paper presented by Frank Webb from Business Clarity and prepared for CMAC. While this information has been extracted from the ASIC guidelines on their official website, it must be stated this information is general in nature and cannot be construed as professional legal advice. A company is a separate legal entity. As far as the law is concerned, a company has a distinct legal existence that is separate from that of its owners, managers, operators, employees, and agents. A company has its own property, its own rights, its own obligation. A company's money and other assets belong to the company and must be used for the company's purpose. The company also has the power of an individual, including the power to own and dispose of property and other assets, enter into contracts, and sue or be sued. Personal liability as a director. Once a company is registered, its separate legal status, property, rights, and liabilities continue until ASIC deregisters the company. Your obligation as a director may continue even after the company has ceased trading and has been deregistered. Under certain circumstances, you may be personally liable as a director for the company's debts and other losses. The members of a limited company are not liable in their capacity as shareholders for the company's debt. As shareholders, their obligation is to pay the company any amount of unpaid on their shares when they're called upon to do so. However, members can who are also directors may be personally liable under certain circumstances, and it's these circumstances that we're going to outline. So the key areas of potential personal liability for you as a director are debts incurred when the company becomes insolvent, company's losses caused by breach of directors' duties, if you act as a guarantor or provide security over personal assets, and debts incurred by the company acting as trustee, and illegal Phoenix activity. We'll consider these and other regulation actions that might be taken against you, and we'll go through and we'll look at each of these in a little more detail. So, debts incurred when the company becomes insolvent. You may be liable for the debts incurred by the company at a time when the company itself is unable to pay those debts, as and when they fall due. This is because one of the fundamental duties of a director is to ensure that the company does not trade while it's insolvent. This is really important. That's why it's important to be across the financials in the business and understand them. A company is insolvent if it cannot pay its debts when they become due. Common signs of insolvency include low operating profits or cash flow from the business, problems paying trade suppliers and other creditors on time, trade suppliers refusing to extend your business further credit, problems with meeting loan repayments on time, or difficulty keeping within overdraft limits, and legal action taken or threatened by suppliers or other creditors over money owed to them. This is why it's really important that cash flow management is a key part of the operation of the business, and it needs to be constantly monitored and forecast. So, to determine if a company is trading while insolvent, the directors need to be across this. You need to be able to assess this. The cash flow of the company. You need to determine whether the cash flow, the anticipated future cash flow, will be sufficient to enable you to pay the current and future debts as and when they fall due. In other words, you can be overdrawn at a point in time, But further down the road, when you're due to pay your bills, if that money has come back into the bank account, then you're not technically insolvent, because when the bills fall due, you can actually pay them. So the financial position of the company in terms of its assets and debts, it has as a whole, and this is looking at the liquidity, the company's liquidity, and its ability, it can actually sell off assets to pay debts as and when they fall due. If you allow the company to trade while insolvent, and this is really important, you need to be across this, you will be acting illegally and be in breach of the civil and criminal provisions of the Corporations Act 2001. So, company losses caused by a breach of directors' duties. Directors have what's called fiduciary duties, and that means you put the company above yourself, and you look at it, and you've got to be able to distance yourself in your role as a director from what's happening in the business and your personal position. So another way that you become personally liable as a director is where, as a result of you having breached your duties, you have caused the company to suffer some loss. Under these circumstances, you may have acted illegally and be in breach of your civil or criminal provisions of the Corporations Act 2001, and you may have to compensate the company for the loss. It is important to remember that directors' obligations may continue even after the company has ceased trading and has been deregistered. If you're a guarantor or you have used security over a personal asset, as a matter of commercial practice, a bank, trade creditors, or anyone else providing finance or credit to a company may ask you for personal guarantees of the company's liability, some form of security over your house or personal assets to secure the performance of the company over this obligation. And you may, for example, be asked by a bank to give a mortgage over your house to secure the company's repayments of a loan. If the company does not repay the loan as agreed, you may lose your house. It's important. These are the things that we want to avoid in this structure, so that we don't give personal guarantees and we don't use our private properties as security. It doesn't work like that. So it's very important that we keep that in mind. And any action to do this needs to go to the board, and you'll discuss it as a group and determine what's going to happen, and that will go back to the group and you'll talk about it. Obviously, not a desirable situation, so we'll look to get away from that. So where personal guarantees are provided by you, you may become personally liable for the repayment of the company's loans or debts. And the whole idea of having a proprietary limited company is it puts a step between you as an individual and the risk of the company operating on its own. But if you carry out your duties as a director correctly, you're never in that situation. One of the key things is to ensure that the cash flow of the company is monitored and you're always viable. So debts incurred by the company acting as trustees. This is not really relevant to CMAC, but it could be relevant to the trust that's going to be sitting over it. So if your company is acting as a trustee, in some circumstances you may become personally responsible for liabilities incurred by that company. For example, if the trustee company breaches the terms of the trust. So a trust, like our company, like the co-op that we're looking to set up, will have clear rules as to how it should operate. And that's one of the things that we need to look at later. So there are serious consequences of failing to perform your duties as a director. And we'll talk about that. That'll be another presentation, and we'll talk about responsibilities of a director. But we'll just go through this liability thing here. So illegal phoenix activity, and I'm sure you've heard in the press about phoenix activity, about businesses that have, a phoenix is the bird that died in flames or died and rose up out of the ashes. And that's where the idea came from for companies that have folded. So illegal phoenix activities covers the intentional transfer of assets from an indebted company to a new company to avoid paying the creditors. In other words, this company here owes the creditors a lot of swag of money, and it transfers that money to someone else, and then it just folds. Not a good situation. So illegal phoenix activity is a serious crime and may result in company officers, directors and secretaries being imprisoned. This practice severely disadvantages creditors and gives the business operators an unfair competitive advantage. In other words, they've gone ahead and they've done this work and they've charged the client for it and they've been paid, but they haven't paid the creditors. So it's a very unfair advantage for other people in the industry. While illegal phoenix activity can take many forms, the key characteristics are that the company fails and is unable to pay its debts. The company acts in a manner that intentionally denies unsecured creditors equal access to the company's assets to meet and pay debts. Soon after the failure of the initial company, usually within 12 months, a new company commences that may use some or all of the assets of the former business and is controlled by parties related to either the management or the directors of the previous company. And directors who engage in illegal phoenix activity may be acting in breach of the civil and criminal provisions of the Corporations Act 2001. Including the more general directors' duties under the Act outlined at directors' key responsibilities. Other regulatory actions against directors. While you have numerous duties under the Corporations Act 2001, which is administered by ASIC, you may also be liable for breaches of laws administered by other agencies. For instance, you may be held personally liable for certain outstanding tax obligations of the company under the ATO's director penalty regime, particularly in circumstances where the company has employees. As a director, you may have a legal responsibility to ensure that your company meets its PAYG, withholding, and superannuation guarantee charge obligations. This was a recent change in the Act and gives the ATO the ability to really chase these people down. So if the company does not meet these obligations, you may become personally liable for a penalty equal to these amounts. The consequences of failing to perform your duties as a director. If you fail to perform your duties as a director, you may be guilty of a criminal offence with a penalty up to a maximum of $200,000 or imprisonment for up to 5 years or both. Have contravened a civil penalty provision, and the court may order you to pay the Commonwealth up to $200,000. Be personally liable to compensate the company or others for loss or damage they suffered. And be prohibited from managing. So the government has put a whole lot of rules in place to ensure that this is done correctly. But at the end of the day, you're still protected by the proprietary limited company. And that the protection there, if you do your fiduciary duties correctly and everything, is just the unpaid portion on any shares that you have. So that's your maximum liability. So this is just to give you a bit of an overview. We'll do another one on what directors' responsibilities are. But if you've got any questions, just direct those questions to the committee members and they'll bring your questions to the meeting and we'll get some detailed professional advice for you, because this is just a general overview. Thanks very much for your attention, and I hope that this has given you a bit of a help.